Let's face it, nobody likes lawyers. They never give a straight answer, they dress all stuffy, and worst of all, they charge so much money. Unfortunately, if you get in big trouble with your landlord, that could become a legal problem. In an eviction lawsuit, you'd be a defendant, and normally you'd want a lawyer if you're a defendant. But most tenants can't afford lawyers, so they wind up trying to figure out the law on their own. This can wind up with tenants getting really confused, or worse, getting really confident about what the law is, but they wind up being wrong about it. This video is meant to help people avoid some of the most common myths surrounding landlord-tenant law in Utah. Which brings us right away to our very first myth. But I saw online that if a landlord... Let me stop you right there. Eviction law varies wildly from state to state, and the outcome of an eviction lawsuit can change wildly based on even small differences of wording from one state's laws to another. If you're renting in Utah and doing research about eviction law on your own, only trust sources of information from Utah. Let's say your landlord comes into your home unannounced, but your lease says they have to give you 24 hours notice before coming in. This is something that people often want to bring up during an eviction lawsuit because they think the landlord's bad actions mean the tenant can't be evicted. Yeah, I'm not giving my money to someone who acts like that. How can I be evicted after they've invaded my privacy? This rarely works as a legal argument because most judges believe in the idea that two wrongs don't make a right. Meaning, even if your landlord has done something bad, they can still evict you if you did something like not pay your rent or committed a crime near the property. Example number 1. To use our earlier example, unless your lease says otherwise, landlords have to give you 24 hours notice before they enter your apartment. But some landlords don't know that, or they know, but come in without warning anyway. This bad action by the landlord is not a defense to eviction. Example number 2. Likewise, Utah law does not allow tenants to withhold rent anytime there are unpleasant or unsafe conditions. Some states permit that, but not Utah. So does that mean my landlord can just do whatever they want? No, you could still sue the landlord for their bad acts, but eviction lawsuits move much faster than the kinds of lawsuits you could bring against the landlord. For most any lawsuit a tenant would bring against a landlord, the timeline from the first court papers to the landlord having to respond to those papers is 3 weeks. In an eviction lawsuit, the timeline is only 3 business days. And that's just the start. The rest of the eviction process moves really fast, too. Meaning, if your landlord sues to evict you and you file a lawsuit against the landlord that same day, the judge might sign an eviction order before the landlord even has to make an initial response to your lawsuit. Related to that, myth number 3. But this is discrimination. How can they evict me when they're violating federal law? This relates to that earlier concept of two wrongs don't make a right. 99% of the time, the events that lead to an eviction, non-payment of rent, not doing something you're required to do in the lease, or doing something prohibited by the lease, are considered legally separate from the events that lead to a discrimination lawsuit. Plus, remember what we told you a moment ago in myth number 2. Most every other lawsuit in the world, including a housing discrimination lawsuit, takes a lot longer to go through the courts than an eviction lawsuit. Meaning, even if you have a slam dunk winning claim that the landlord did something discriminatory against you, the eviction will simply take place faster. Your discrimination lawsuit might still win and provide you some compensation later, but by then the eviction will have already taken place. If you believe you have been discriminated against, you should file a complaint with the Anti-Discrimination Division of the Utah Labor Commission for investigation and possible mediation, and contact the Disability Law Center to see about further investigation of your discrimination claim. That being said, there are very rare instances where a discriminatory action by the landlord might make out a defense to an eviction. However, because it is so rare, you should not assume that your case is one of those exceptions unless you have talked to a lawyer first. Let's say you get an eviction notice, or you know an eviction notice is on the way, so you go talk to your landlord about the situation. Maybe it's even a really friendly conversation, and they tell you they're cutting you some slack about a problem, or that you reached some clear agreement about who was going to do what. But then you still get an eviction notice or court papers about the same problem. That brings us to myth number 4. But my landlord said they would work with me. How can they evict me when we're still negotiating? It's understandable that you might be upset by this. After all, any lawyer will encourage you to communicate with your landlord and do everything you can to resolve a problem before the situation escalates into an eviction notice or lawsuit. However, if the landlord said they'll work with you, but you never reached a definite agreement, they still have every right to evict you. An example of a common agreement that isn't considered binding on a landlord is when a tenant asks if they can pay overdue rent at some point in the future, but without establishing a clear and definite date for payment. Also, even if a landlord says they'll work with you, that doesn't mean they have to agree to what you eventually ask them for. If you reach a definite agreement, oral contracts can be binding, but proving who agreed to what and when they agreed to it is harder than most people think. If the conversation was only you and your landlord, and the landlord denies that they agreed to what you say they agreed to, then the judge just has to decide whether he believes you or the landlord's description of the conversation. That is a very risky position to be in as a tenant. If the landlord is evicting you because you did something bad other than not paying your rent, they probably need to have a witness testify in court. Usually, that person is an employee of the landlord, like a property manager or a maintenance worker, or maybe another resident in the building. But what if what they're alleging or testifying to just plain isn't true? That brings us to our 5th and final myth for this video. None of this is true. I never did that. They just don't like me, so they're trying to get rid of me. And that very well may be true. However, even if the landlord's witnesses lie, there's no such thing in a courtroom as objection. That's a lie. Judges try their best to figure out the truth, but they can only decide based on the evidence in front of them. Your testimony counts as evidence, but a landlord who has more evidence than you is likely to get an eviction order against you. Remember, if you have witnesses who can't or don't want to come to court, a letter from them to the judge will not be accepted as evidence. That person must appear at court in person in order for the judge to consider their testimony as evidence. Meaning, if your landlord is accusing you of having done something and you don't have any evidence to disprove that claim, then the judge will likely sign the eviction order. Thanks for watching. For more information, visit the following websites on Utah eviction law.